Hi, hello, good evening. Welcome to Telugu NRI Radio Facebook Live on immigration, the webinar. So we see some technical issues. That's why it got delayed for 5 minutes. Sorry for waiting and sorry for interruption. So yeah, we will go to live. You're seeing the new person here. So Lucas, we will welcome to Lucas today's show. Hi, Lucas. Welcome to today's show.
Hi, Venkat. Thanks for having me. Yes, finally was able to get my vaccination and wait the 2 weeks. So now I'm back to normal.
I think everything is normal, but unfortunately, some countries still have spike on coronavirus. Be safe and please be vaccinated and get safe. And yeah, that's from our side. Yes, Lucas, we can go to the show. What is any good news?
Yeah, there is some good news. Following up from our discussion last week, we, actually saw a few letters that have already been sent out in regards to adjustment of status filing to correct the missed filing from previous in October and November that was led to rejections. And USCIS on a few occasions has sent out letters that we know of to other that I've seen from other attorneys that allow them to refile. So if you do receive this letter and you wonder why you received a letter from USCIS stating that you can refile, just coordinate with your attorney, and that's good news, and hopefully everyone can be taken care of with this new update.
Okay. So is any new update on CAP 2022 process? H1B CAP 22.
CAP 2022 is officially underway. We have all of our cases selected for the first batch for both regular and master's CAP quota. We'll have until June 30th of this year to go ahead and submit all the petitions. As of right now, premium processing is available. So, we can go ahead and go through that as quickly as possible. Again, on all the selection notices, it will tell you exactly where you're supposed to submit the package, from anywhere from Nebraska, Texas, Vermont, California. It's just a random selection, regardless of wherever the petitioner might be located. So, once all that's completed, we expect the second lottery to go ahead and be conducted in August, much as it was last year.
Okay. So we know that after we got the lottery, we have the 90 days of time. So is some reason it maybe everyone will be ready to submit all document. Some reason if got delay or something, the USCIS will consider those application petitions, or USCIS will not consider whoever applied after, whoever submitted documents after provided the date.
So you're referring to the June 30th deadline, correct?
Yes.
As of right now, the notifications, we have an extra 30 days for RFEs, notice of intent to revoke, notice of intent to deny, 290B filing. But unfortunately, we need to adhere to that deadline for filing H1B CAP subject petitions. Anything that does arise or anything that comes up, it's always best to take care of these cases before, file before that date as soon as possible. That way you can mitigate any problems. If, maybe there was a rejection or something like that, it gives you opportunity to go ahead and refile before the deadline.
Okay. So is there anything we need to take it as the petition perspective? Is there they need to take any precautions or any?
Well, it's, I haven't received any official feedback this year from any of our cases. It's still fairly new. We're in the process of filing our first batch. So it'll still be some time before we see if there's any new RFE trends or if there's anything updated. As we all know, last year, I think the major RFE issue that we had was just basically how the beneficiary or the employee maintained status while they were in F1 and changing their status over to H1. So, sometimes there's issues where, unfortunately, someone's not picked when they're in their OPT, post-completion OPT or STEM OPT, and, they have to then go for second masters and do CPT. So, whenever we get to that circumstance and we get RFE, it's just a lot of documentation, but I would expect this year to go much the same as last year. As far as that goes, I don't really foresee anything new coming out as far as a more difficult RFE or anything like that.
Okay. So, yeah, we can discuss the next topic as a very important, the pending immigration bills. The way we see the couple of bills approved in House for those are DACA and might be it benefited to the illegal immigration. So, but how we long advance as for the employment immigration bills? Do you have any update on that one?
Yes. So, what we're looking at now is we have a large crisis that's occurring at our southern border. There's a lot of unaccompanied minors. There's a lot of people seeking asylum. There's a huge influx of people trying to arrive in the United States. Before, I think, either of these bills that have already passed the House and are currently in the Senate move one way or the other, I think that issue has to be addressed, and I think that's what the administration is currently working on. I think you have to see some sort of humanitarian assistance at the moment focused on that before we really get into any other type of comprehensive immigration reform. And I think, in tandem with that, you have a lot of existing court cases where, we have a 1.3 million case backlog at the moment. So what we have to look at is, how can we effectively mitigate the backlogs for that before we can really get into this next phase of proposed change, with including the employment-based backlog. Now, as we discussed last week, good news with this front is we received an update from Department of State, last week as far as what visa allocations are available. And again, due to the limitation of people being able to access the family-based visas, there's quite a few visas that are going to be rolled over into employment-based again this year that we can see also beginning in October. And it's supposed to be, at this point, from what we're hearing, is going to be a greater number than was even available last year when we saw such a tremendous movement with the visa bulletin. So going back to your conversation with the proposed comprehensive immigration reform bill addressing the backlog, I think when it happens, it's going to be probably later on in the summer, and if it's working in tandem currently with these other reissued visas, I think we could see significant movement within this next year for people who would then qualify to obtain their GC. So there's going to be historic movement one way or the other this upcoming year. So it's very exciting.
Okay. So here we are discussing the immigration bills and family-based immigration. So let's discuss about the family-based immigration. As of consulate, all consulates are very busy, very demand for the visas. I think the visa slots are not getting to everyone due to the pandemic situation. The slots are very limited. So we know that department status is going to be add more number to the employment-based green card, which is left over from family-based. Generally, as of now, today we are April 7th, from October to April, almost 6 months, all right?
Mhm.
So do you see how long this going to be? USCIS will not issue to the family-based green card on consulate process. We can expect or more. We discussed about it will add 150,000 plus, but eventually in situation across the globe, all got it meant the COVID is the strain is going up, but look like we don't see any prediction the consulate will work 100% full-fledged. So if the same situation, will we maybe expect more number to add employment-based green card?
I think so. I think from what we heard 2 weeks ago was, the update was there's so far throughout, we're halfway through the fiscal year. I think that there's so many unused visas that trend will continue. And I think, as most people know, that Europe is still very much a hot spot. India is becoming a very major hot spot, and each country could be conditioned, once things kind of normalize, if there's a large outbreak in a certain region or country, that would also obviously impact any appointments, period. And then we're kind of going back to square one where we were, as far as last year. So, yeah, I think we spoke about the number of visas added, and I think there's a lot of optimism for more to be added. But as of right now, we don't really have an exact number. But let's take a hypothetical here. If we have those visas, let's say 20% more than were available last year that went to employment base, if that happens this year, and let's say later this summer we have the employment-based backlog part of a bill is introduced and passed, that alleviates the backlog, that allows children to not age out, that counts each family as one rather than each individual in the family counting as one visa, right? So if we have all those changes at minimum, and the bill is enacted within 6 months of passing, literally by this time next year, we could see the full benefit of both the employment-based visas being available, and then also the diminishing effect of this backlog, and then of course, keeping families together, and then each family only allocating one visa. So it would be a huge movement, unprecedented movement in that regards for employment-based visas.
Yeah, definitely, Lucas. If bill pass and if we'll treat it as a one visa number for one family, we could potentially see the it will minimize the backlog of green cards. So everyone is looking for the bills when will going to be on floor and whether we'll approve or not. What are the main points to discuss in House and Senate? Is any stopping point, or is any point to not approval? Just everyone looking, but as of now, we don't see any progressive on bills. Hopefully, we will see that in future, in maybe a couple of months.
I think everyone should keep in mind too. When these bills were introduced, I think the bills with the least amount of maybe hope of going through and passing unchanged are the ones that have been introduced first. And I think the ones that have a higher chance of passing through would be the ones reserved for later. So I think in this sense, it bodes well, like what we've been discussing, how this has been introduced as a piecemeal, which means, piece by piece, instead of a bill as a whole. And I think you and I went through the proposed bill that was as a whole maybe a month ago. And, this is actually, very good news. If anything is passed, which I think there has to be something passed for immigration, it most certainly is going to, be focused on employment-based. I think the easiest thing to really get through at this moment with this Congress of the Senate is going to be, we want, highly educated people adding to the workforce, more security for their families, less, uncertainty, things like that. And I think that's something that we can look forward to seeing within this next year.
Okay. So then we can go for next topic is prevailing wages. What are the changes? Do you see any changes are going to be, or the DOL are going to be implemented in any new rules on H-1B prevailing wages or green card prevailing wages?
So the final rule is still under consideration for the prevailing wages, much like what we looked at last year with the wage levels. We expect everything to more or less continue, to kind of go back to the way it is, to stay the way it is now. We also, put out notification this week that, Department of Labor is looking to streamline the process and help speed up these prevailing wage determinations. So most people that in our audience that would be familiar with, the first part of the PERM process or labor, you have to submit a prevailing wage. Historically, this takes about 2.5 to 3 months to receive, the prevailing wage back from the officer. We're seeing it now at 4.5 to 5 months to be issued. And there's some changes. We don't know for sure yet what's going to happen. There's a conference call that anyone can dial into and listen with a DOL representative in a couple of weeks or I think next week, that allows, that will give us more insight. But it's supposed to streamline the process, make this process easier for employers, which means, there's less burdensome task of waiting so long and trying to time the ads for these laborers. So, that's one good change that's up on the horizon at the moment.
Okay. So, about H4 and L2 biometric, do you see any progress on waiting, pending on biometrics and waiting for green H4 EADs?
Well, some good news that has come out in the past week, 2 weeks now, is, there's a major lawsuit filed in DC that incorporates, the processing delays and other issues involved with, H4 EAD, L2 EAD. And specifically, with these two employment authorization documents for these categories, the applicant who's applying for this is not permitted to continue working once they receive a receipt. Now, there's quite a few visa categories that one can have to get employment authorization. Most like GCEAD allow you to work on the receipt after your EAD expires for 6 months until you get your new card. H4 and L2 do not allow you to work under those categories. So, there is a bit of an issue if it's taking 6-7 months to get the card after you apply. There's no real effective way that you can continue working, for 3 or 4 months of the year, then have to stop again, so on and so forth. So this litigation that's proposed is going to be a class action in nature. The biggest hurdle you have in any class action is at the class formation. So what we have to do is we have to get the court to say there's enough people that have the same issue or in the same circumstance that would qualify as one plaintiff in this cause. So once the class is certified, or once everything moves forward that way, everything else goes quickly. But the biggest hurdle that the attorneys would have in this instance would be certifying the class so that they can move forward with litigation to hopefully get change, with USCIS and get this problem corrected.
Okay. Lucas, here, just I would like to discuss about the famous law firm sue on the USCS about the biometric process. The here USCS will wait until judgment comes, or is there any way USCS will negotiate with the law firm and maybe based on current situation, they can come up with new process and new rules? Is there any chance to USCS still wait until get the judgment? Or
Yeah, I think that's a real possibility. Typically, so today we have a few cases pending, lawsuits pending for individuals, and today we'll work one-on-one with maybe a U.S. attorney or someone like that in regards to that issue, and try and resolve that issue accordingly. Sometimes this results in the agency acting and correcting the mistake, or approving the case, and then the case is just closed. In an issue like this, I think the agency, this is more of a policy issue. So what you would have to look for would be, what is the executive branch's position, which is the President of the United States. What's the position on these delays? Is it really necessary to have biometrics scheduled for H-4 visa holders, L-2 visa holders? What was the statistics in regards to how many H-4 visa holders are committing crime or evading the authorities, or and I would pretty much challenge anyone to show me one or two cases out of 300,000 or 400,000 H-4 visa holders. I mean, it's just, I think the statistics are on our side to say it's pretty much an unnecessary step. And I think, if the administration agrees with that, maybe they'll not challenge the lawsuit too much. They'll make the changes. But the policy reasoning behind this, sometimes you really have to push these issues in a lawsuit, because the policy changes can take quite a bit of time. If this issue really pushes that bullet point to the top of the list as far as a policy agenda and changing, it's a positive thing. But it's really a wonderful work by the team that's conducting this. They've been very successful. This is the same team that has filed lawsuits against USCIS, changing that it resulted in the memos being rescinded, as far as the third-party offsite employment memo and the Neufeld memo, which is the right to control. So, I actually think that they're going to be pretty successful with this as well. But, as with anything, once you go through the courts and you litigate, there is a bit of uncertainty of what could arise, or, what could happen.
Okay, that's a good information. Lucas, here, let's say the bills come to judgment. Let's say a judge give the judgments towards the H4 and L2 beneficiary. Court say that, hey, we need to change the policies, or maybe revert to whatever the H4 and L2 biometric policies. Once the judgment given, after how long it will take to implement these new changes of policies?
Well, that's something that would be addressed at the court hearing. So usually, let's say with the I-129s for H-1B visa holders, anything filed with that petition, maybe there's certain adjudication processes and procedures that are done. So, to just say, hey, here's the judge said to do this, in some circumstances, it's impossible to change the field manuals, to update forms, to do, certain things that might not be required anymore. On the other hand, maybe a change like this, if the judge orders that, hey, we need to speed up the processes and procedures, maybe it doesn't take as long to make the updates to not require biometrics. But in any sense, usually on average, it's about a 30-day grace period probably the government always requests additional time beyond that. But I think as a rule of thumb, I think the courts typically give 30 days for the agency to go ahead and adjust their policies and procedures to reflect the court order. But even that short period of time, 30 days seems like a lot to you or I, but it's quite a bit whenever you have to go in and change processes, procedures, field manuals, rules. It takes a little bit of time.
Okay. The event judgment came to favor of the H4 and L2. It will take some time to implementation revert back. So,
yeah, typically it's about 30 days. And of course, if there's an extreme case, there could always be something in the order that says anyone who's had a pending application for more than X time, they might say that receives priority over others. So, that's all something that could be put in a court order. And that would be something that's negotiated between both the government and the attorney representing all these plaintiffs.
Okay. So here, can you suggest, let's say, if any H1 extension, so with single packet with H1 and H4 EAD apply, do you recommend to do in premium process?
Well,
at the moment?
So it's a very good question. I know I've discussed with a few people, and it just really depends on your situation. So in the sense of premium processing, if I file H4 EAD with the principal H1's petition, there's not really any benefit currently for H4 EAD. So you would have to look at, is the principal H1 visa holder, does it make sense for them to go ahead and get the case approved? Are they pending travel? What are the circumstances surrounding that to warrant the premium fee? Now, in the future, I'm expecting, hopefully, that we get back to the way things used to be, where we could submit one package for one family, and once the principal H1B is approved, then since there's no biometric requirement, then the H4 extensions and EAD would also be approved shortly thereafter. Okay.
Now, here is the scenario. Let's say we apply the one single packet for principal applicant and H4 and H4 EAD. Mm-hmm. At the moment, even apply the one single packet, it will divide to the two process.
Correct.
So, by maybe next couple of months, let's say next 2 months or 3 months, maybe court will quote the judgments to the H4 and L2 favor. The USC is going to be implemented the previous maybe new policies or eliminating the biometric. Maybe after 3 months, if you upgrade it to premium process, in this scenario, anyway, H1 will be adjudicated within 14 days, right? 2 business mm-hmm. weeks. It's the same way. It means H4 and H4 EAD will adjudicated in 2 weeks, 2 business weeks, or it treated as a separate process.
It'll still be a separate process. So you have to look at the time of filing. Whenever we send them into the service center, they have currently for H4 and H4 EAD, there's a whole, it separates from the H1B case, and it's going to go through its own procedure and process, registering for biometrics and things like this. If a court decision comes in and changes that, it's still not going to reunite the package with the H1B principal applicant. It's going to proceed and, be adjudicated individually. Now, I want to encourage everyone who's listening or who will watch this in the future. It's very important at the moment. You should not make a decision on filing premium or not, or upgrading or delaying your filing based upon what's happening. This case was just filed. There's a lot of timing that goes into this. The government has pretty much 2 months to respond. to an action like this, then there's still other hearings, and this could very well be many months before there's a final resolution. So typically you file your extensions within 6 months of your I-94 expiring. So we don't want anyone to really wait till the last minute. That's something we don't want to do. We want to go ahead, proceed as if things are going to stay the same in the near future, and make decisions based on that accordingly.
Okay. So we saw a couple of EADs, or maybe green card EADs, is educated, whoever their biometric already existing with agency. USCIS is releases the green card EADs, and the same scenario, will it apply for the H4 EADs, or it should be the H4 EAD and the L2 EAD, it should be processed to biometric, then once they get the biometric, will adjudicated this applicate?
I've seen it both ways, where, if a biometric's on record, they will go ahead and process saying, we still have a biometric on record. I've seen it for both the H4s, or other visa categories, GC, EAD, things like that. So it's really a case-by-case basis, and it's depending on whether or not the information is still on file.
Okay. Yeah, it was H4 and L2 EAD processes. I think is a long waiting. The application. Most of the people are waiting for the biometric process. Yeah. Hopefully, it will resolve soon. So, Lucas, we can go for the next topic, the 485 adjustment of status updates. Do you have any updates?
I think we had some positive news, like we discussed at the beginning, where due to processing delays for the rejections, again, just to recap, last October and November, the Texas Service Center received, substantial amount of applications, a historic amount of applications submitted at one time. And this caused a lot of processing delays as far as like rejected packages and things like this. So if a package was rejected for being incomplete or not completed correctly or something like this, it would, I think some of the packages might not have been received until early this year. So that if you submitted something in October and it takes 3 or 3.5 months to get the package back, you miss your opportunity if the filing ability has changed. So USCIS has acknowledged this, and I've seen a letter that was posted to American Immigration Lawyers Association, notifying all other attorneys that these notices are being sent out. Basically, USCIS will send out the notice saying, your case was rejected because of this, due to processing delays. We're going to permit you to resubmit your rejected application, et cetera, et cetera. So if you receive this in the mail, typically the applicant and the attorney will both receive a copy. If you do receive it, it's good practice. Go ahead and inform your attorney or whoever filed your case to, we received this. And if you filed on your own, that all you would need to do is basically include that notification along with your rejected packet, and then resubmit that to the correct service center.
Okay. Do you see any adjudicated for I-140 adjudicated, whoever downgraded to EB2, EB3? Do you see any approval notice?
We haven't yet. Most everyone I've downgraded, we're trying to hold and just maintain the process. There's no real need to push for premiums. So I haven't seen many biometrics for people who downgraded, and really all the people that I've seen that have had EADs already are all pretty much people who filed with a supplement J. So there's no downgrading involved. And again, the downgraded petitions is just historic. The volume that went through and it was being processed here at the Texas Service Center.
Okay. Lucas, we have a caller. Do you have any question I think a Nebraska number.
Yeah, yeah. All right. Can I go ahead?
Yeah. Yes. Your name, please, and go ahead. You can ask.
Yeah, I'm Pradeep. Thank you, Lucas, for taking my call.
Hi, Pradeep.
I have a quick question. So, yeah, hi. I downgraded from EB2 to EB3 in the month of October 2020. And basically, like, I got biometrics, all of that done. And then I did a premium processing of my I-140. And initially, it was rejected. And then subsequently, after 30 days, they accepted it. And now the problem is I got an RFE on that I-140. Essentially, what has happened was attorney, when attorney filed I-140, she used my latest position, the promoted position, than what was originally filed in perm. But the job description, everything is same, but just the job position is different. So USCS came back with an RFE asking details about that. Why, I mean, the position is not exactly same in perm, and they wanted an additional evidence to support my case. So I just wanted to talk to you and then find out how should we proceed with respect to that. What would be the better way of replying to that RFE to ensure?
I'd have to know more detail to that, because whenever you file a downgraded petition, it needs to use the labor that was filed to support the original I-140. So the issue with this is your attorney has filed something that does not match what the ETA 9089 had showed that was filed previously, right? So in this sense, I don't know if we would, how you would address it depending on the size of the company, or what other circumstances there are with that, because you would, maybe a company that's large enough would say, this is the position that was filed. This position has been modified now due to technology change, due to, et cetera, et cetera. Maybe there's a different title that goes with it, much like, whenever you're working in Java, along comes Java J2EE, things like this. There's enhancement in technology. So maybe if your labor was filed, going on 6 years ago, 7 years ago, maybe there's enough change. That's a possibility to analyze. It's a difficult problem to resolve, and without more, it's a very specific issue. So without seeing more information or knowing more, it's hard for me to tell you my official opinion, but it's a generalized idea of what to do. I mean, I think you could say that, the technology, the IT industry is always ever changing, and what one position might be defined as at one point in time might not exist anymore. That might be a way of going about this. And so if you went to Nebraska, is your petitioning company, or is it located in California, or?
It's Nebraska. So it's one of the Fortune 500 companies. So it's a large organization. So I don't know if it was a clerical mistake made by attorney or it was done with a purpose. So which attorney?
It's probably not anything done on purpose or anything like that. It shouldn't reflect anything. I think, even USCIS notates this. Now, this is different because typically in this circumstance, you need to have a matching, you have to utilize the pre-existing ETA, but USCIS as a whole, especially when we look at H-1B adjudications, they typically don't go by position alone. They define a specialty occupation and things like this based upon job duties. So I know this is not the exact same thing, but I think one argument could be made is that, we're looking at the essence of the job duties, the core functionality of what your position is that was originally filed for. And due to the changing technologies or changing industry, the norms used might be A, B, and C. So depending on how large your company is that you work for, depending on the sector you work in, like if you're an SAP person or if you're Oracle or whatever your What field do you work in?
Java. It's a transportation domain, and I work on Java technology. Java.
So
it's just a slight promotion.
Yeah. So as you see right there, like that example we used with Java J2EE. You know, I don't know if J2EE was predominant whenever you first filed the labor, but that's something.
Yep.
You know, that's been expanded upon here recently, right? So that's an argument that can be made for that.
Okay. Yeah. So you think, Attorney Lucas, do you think it's still, the chances of it being approved is good enough, considering the situation? I mean, basically, attorney, when I talked briefly with attorney, right, my current attorney, they have a similar argument like what you have mentioned, wherein job duties govern, the term and then the approval of I-140, but it's not the job position as such. I don't know if it's going to be valid or not, but that's what is the argument that they are planning to make in their reply to RFE. So I'm really concerned, if something goes wrong, it's a new petition that was filed at the time. I just wanted to make sure they don't go back and deny the old one, which would take away my chance in filing,
in the future.
Yeah.
What's your priority date at the moment?
October 2014.
Okay. Hopefully it can be resolved. I still think so depending on when you receive this RFE, there's a little bit of strategy I think that you should work with your attorney on. So if you just receive this RFE, you're going to have your typical time to respond plus 30 days because of COVID-19, right? So if you could stretch this a little bit longer than normal and we get closer to October again, I would wait and see closer to that date. And I would assume you're maintaining your H-1B status still, right?
That's correct. Yeah. 60 days COVID relaxation still comes out to be the last date would be around September mid. So hopefully September 1st or so if the visa bulletin comes up, that will be great. Or else,
exactly.
You would have to take,
The reason I say that is if you have an emergency where you have to travel, you still have the advantage of using the advanced parole if you needed, if you don't have a stamp, right? So if there's an emergency, I know there's a lot of families suffering, being separated. Maybe mom and dad have illness and you go to support them. You want to have that available as long as you can, because if like Venkat and I discussed earlier, maybe if the cases grow and get worse, maybe they're not going to allow stamping again or something like that. We don't know. So I like to always tell people, keep your options open to make sure that you have the most ability to maneuver until the deadline's there. That's the idea.
Okay, got it. Thank you. Yeah, but now that I remember, it's still going to be, I calculated wrong, it's still going to be mid of August is when the last date that we have to respond back to the RFE.
Okay.
It was other than the position, everything looked good. So, and the ability to pay, I think that there is no issue from that standpoint. It's just the position that was marked wrong. So.
What was the two positions, if you don't mind?
So one is the one that's there in the term is senior project engineer, and the one that's there on the I-140 is associate systems engineer. It's one level up than senior project engineer, but the job responsibilities are pretty much same, but you'll have some additional responsibilities in the new one.
So typically, as long as again, not knowing your case 100%, just a generalized discussion, I think that's a good strategy they have, and I think the argument should be pushed saying that We don't really look at the job title, but we look at the job functionality, and maybe go forward with that, and hopefully, touch wood, hopefully everything goes well for you, and this is just a minor bump in the road.
Mm-hmm. Yeah, it's really unfortunate. I think, according to Attorney, right, so they have done the same thing for many other folks, but it's just that they randomly picked or something, I don't know. So it just happened to me alone. So other folks with the same situation, they are getting approvals.
Well, I mean, I always like to tell people this too, and I want you to take it to heart. Even if that happens, I always tell people you never have the same case ever as anyone else. You're always going to be unique in some way. Everyone is their case is much like a fingerprint, right? You and I don't share the same fingerprint. Now we can go through a similar process together. We both file an I-140. We both downgrade. We both work for the same company. But always remember, there's certain things that keep your case unique to you. Now it's a job of any attorney to make sure we maximize your uniqueness, to make sure that we enhance what your position is, because if we don't want to treat everyone the same, and that's where problems can occur. But at the same time, don't get frustrated, because there's a lot of things that maybe have occurred or might be impacting your case that's unique to you, that has no relation to someone else. Even if the job titles or something might not be the same, maybe it's just bad luck you were flagged for RFE. There's a lot of unique circumstances. So don't focus on that. Don't focus on anything else. Focus on, moving forward, what we can do to address this RFE the best way possible, and hopefully get this approved. That's what I would recommend.
Okay. Thank you so much.
Yeah.
Thank you for calling.
So one last question, sorry, if you don't mind, if it's okay. So you were talking about a lot of filing that has happened in the month of October, right, last year. What is the possibility of filing dates coming back to the same level as it was last year, again in the month of October? What do you have some predictions on that, Lucas? Like, what is your suggestion on that? Like, what could be the filing date that you anticipate in the month of October, just in case?
Well, I think your date, even though it's kind of moved back now, I think it's very 99% certainty your date's going to be available again for filing. Part of the strategy I was mentioning and asking you about the deadline is, maybe if this RFE, if you were able to get close enough to October, you could always request to withdraw this petition and then refile again in October. Now, it would be a little bit of a headache, and you'd lose a little bit of time as far as like the processing and things like this. Obviously, money is a factor, but you would, protect the underlying petition and maybe get around the headache of this. That's one thing to consider. I do expect the dates to actually advance quite a bit more. So you're downgrade. Did you downgrade? Yeah. So you're EB2 2014. Yeah. I don't know if the final action dates are going to move that fast. So obviously the key point here is to get your application filed and to start the GC EAD process. And obviously have that pending, but I think trust your attorney, work with them, and see what strategy they have and what they feel they can do to go ahead and get this approved. But I mean, I think I wouldn't panic too much. Like, this is a one-time opportunity. You're going to have, if the worst case scenario happens and this case is denied, you're going to have hopefully an opportunity to refile again, if that was the situation again this October. Okay.
Yeah, thank you. Yeah. So actually, both me and my spouse had EB2 I-140s which qualified for the date, and in fact, my spouse had a earlier priority date. But we made this choice considering all different things, and then it turned out to be like this. Yeah, and now my spouse moved a different relationship. If don't get started, it may take another year or so to even get to the level of I-140, right? So that's where it's all in a situation wherein we made some calculated decisions and then it turned out to be not in our favor. Yeah. But I really appreciate your time, Lucas.
You're most welcome. If you need anything, you have my contact information. Feel free to contact me offline if you need anything else. And I appreciate you calling and sharing your situation, because I know there's other people in a similar situation to you, and this is obviously hopefully informative to everyone who's listening. So thanks again for the call.
Thank you very much. Lucas, I think this is one of the very important scenario. In this case, if anyone fall into the situation, I think the first thing is very tough to. So I think while applying, maybe it means I'm not sure. I will not comment on that one. Just so we hope to better thing in future if anything happen kind of these scenarios. Yeah.
Well, there's always, I want to just stress this. There's always scenarios that are going to happen. Nothing in life goes 100% according to plan. Everyone that is on your team, attorney, employer, everyone that's a part of this is human at the end of the day. And, sometimes things happen. Sometimes policies or procedures change rapidly to where what some things have been accepted in the past aren't accepted in the future. So you just have to have patience and try and work through the problem and not overreact and be too upset about it. It's just a roadblock. That's the way you have to think about things.
Yeah. Lucas, we have one question in Facebook from Vishnuvardhan. I think he did not get through lottery this year. He attempted all 3 years. The 3 years finished. What are the options for him?
So that's a good question. So if you registered for this year, your registration is valid for the whole year, which is different than maybe years previous. So like last year we had the first round of selections, and then some people weren't selected, and then we were pleasantly surprised maybe in August to see that some people were also selected at that time. So keep your hat in the ring, so to speak, and don't lose faith or give up. You can still have a good chance of being selected. This year, I think we saw a historic number of cases being filed through this registration process, much more than last year. And I think that a lot of those are going to be duplicate registrations in the sense that maybe one beneficiary went to 3 or 4 different employers, and each of those employers filed for them. And of course, if you're picked by one, then that's great. But maybe some people had a lot of fortune and were picked by all 3 or something like this, and they only choose one. So that allows 2 visa or 2 selections maybe to go back into the lottery, and it gives you a better chance this fall. Now, you want to always be careful right now, and especially if you were selected, to be mindful of when your OPT is going to expire. So, either make sure you make the change to go to CPT or start that process, or if you were selected this year, make sure that your case is filed before your OPT or STEM OPT expires so that you're able to utilize cap gap, because most of the OPT is going to expire before the 30th of June. Typically, that's how the institutions work. And so make sure you stay in touch with both your employer and your DSO at your university.
Okay. So just you said that a CPT, it means what kind of CPT you can recommend for this kind of scenarios? The day one or?
Well, so there's a gray area in what we call day one CPT versus other CPT. Typically, as of right now, the way certain regulations are interpreted, we're able to say, day one CPT is fine at certain universities. Now, it's all about the curriculum. It's about the coursework and things like this. If you think about in the grand scheme of things, if someone is doing an internship, okay, and you're going to take a master's course in relation to what that internship is, it benefits you to maybe have work experience in that field prior to taking the course, so you understand what more or less what you get more out of what the course is. So when we say day one CPT, it's a connotation a lot of people use in one sense, but we have to remember, if these universities are offering the opportunity for this, the real purpose is that you're going to get real world experience within the field of study which you're pursuing. So you want to make sure with the university that whatever curriculum you're looking to go into, what other field of study you're looking to pursue, that curriculum matches what your internship is going to be. I hope that maybe answers your question.
Yeah, I think Vishnu, you got the information. Maybe if you have any additional if you want any additional information, just send to email info@bgmmlaw.com. So thank you, Vishnu, for your question. And Lucas, we got one more question from YouTube from Karan. I think he keep getting advice to send in medicals before RFE. So he's seeking your advice for this on this matter.
So I would recommend to keep your money if you can. Don't. There's no purpose to send in medicals. It's not going to move the needle, especially if your final action date is not even current. We don't know what's going to happen. We don't know if there's until your date's current with the final action date. We don't know what's going to happen, and I always recommend let's just wait until it's requested. You can either bring it with you to interview, or you can mail in with RFE. It's not going to slow down your application at all, and especially if your final action date is not even current at the time. At this time, it's really. I mean, I guess you can go and have a physical done by the doctor and make sure you're healthy and have that peace of mind. But it's really it's quite a bit of money to spend on these medicals, especially if you do for your family as well.
Yeah, I think Lucas, here it meant a bit confusion. That's why we got this question, because let's say if final action date come to priority date, USCIS about to adjudicate the green card. By the time, if we did not send the medicals, everyone thinking is USCIS will deny the 485 application. That's why most of the people is raise a question whether we need to submit before or maybe based on their USCIS request, or is any other. That's why we discussed last week intern process, intern filing, right?
Right. So I would recommend your case is not going to be denied because of a missing medical. That's not going to happen. Okay. And the way the policies are set up now, it's just a request that you bring in when you at the time of interview, or whenever your case is being adjudicated, they'll send RFE. So I want everyone to remember right now, whenever you filed your application, your applications are going to go to one service center, right? Whenever it gets closer time to be processed because of final action date, it's going to go to a local field office. Once at a local field office, it could be Dallas, it could be Houston, it could be Nebraska or Lincoln, Nebraska, it could be Oklahoma City, it could be any one of these local field offices. An actual file is going to move from one location to another. At that point in time, that adjudicating officer is going to review everything that was put into that file. So yes, you can mail that in, and some clerk at the main, at the National Benefit Center or wherever your case is going to be, can input and add your medicals, but they're not working on the file in the sense that they're going to adjudicate. The adjudication comes at the whenever the file arrives at the field office, where the officer is going to eventually, do the interview and everything else. So that officer is only going to look for completeness and everything else at the time. It's even common. Like I've been to many different interviews where the officer might want a more detailed job description or something else, and they'll issue an RFE at that time, and it doesn't delay the case processing at all. I mean, once we get the RFE, we get the information, we mail it right back in. It goes right to that officer. So it's real important for everyone to realize your case will not be denied if you don't have the medicals included. And at the same time, I want everyone to remember this: when we filed in this grouping last October, November, we had to send credit reports, we had to send house deeds, we had to send bank statements, retirement accounts. For all the cases we filed, we had an extra 200 or 300 pages of evidence. Well, that's no longer required. That's pretty much now just trash, all that work we did. So much like saying that, things can also change. Now, you're always going to need a medical, but what if there's something changed on the medical where we have to now test for some other, maybe a coronavirus, or what if something's added in the future? Well, you're going to have to redo these tests again. So everyone should just, if it really makes you feel that much better to send the medical, by all means do so. At the end of the day, this is your case. You should feel confident and have the peace of mind. But in all practical matters, it's really not an urgent issue to take care of at the moment.
Yeah, thank you, Lucas, for addressing on the medical reports. I think we passed 6 minutes, 7 p.m. So I think thank you everyone who participated and who you called and posed your questions. We always we ready to provide the more information on U.S. immigration, and we are ready to address your questions and scenarios. Maybe you can connect every Wednesday 6 p.m. Central Time on Telugu NRI Radio Facebook Live. Maybe if you have any specific scenario or any sensitive information, you can also send email to Lucas info@bgmmlaw.com. Lucas will address your question. If you want to talk, maybe Lucas will give the contact details. You can directly call to Lucas and get more information and further process. I think we're done today. We'll see next week. Thank you very much, Lucas. Thank you being with Telugu NRI Radio. So we continue this show every week, and we will ready to serve community. Thank you. Yeah, until bye-bye. See you on Wednesday, same time and same platform. Thank you very much.